here and Mr. Conker is here. Good afternoon. Good afternoon.
Afternoon,
Good afternoon.
61358. On behalf of defendant,
Calling case number 233-45171. This is Mathis Oflume versus Ardell Early in all occupants. May I have appearances?
Kathleen Brock, your Hunter P 78404 on behalf of the plaintiff.
Aziz Khankar, on behalf of defendants, 61358.
Thank you. All right. I'm going to ask this. Are parties able to resolve this matter?
No, we are not, Your Honor.
I believe I have solved the problem if she wants to listen to me.
Oh, okay. All right.
Judge, I would like to refer to the two-page flow chart that I filed with the 552023 with your court, and she has a copy also. On the second page, I did a calculation. He paid $11,400, the plaintiff, and plaintiff has a outstanding tax bill of $3,939 with the county and $2,770.
Hold on, Mr. Conker.
Just very.
What are you talking? What are you? Can you start over? Because I'm
The second page, Your Honor, flow chart.
sorry. Of what?
Here, the 55/2023. I filed with your court, and Ms. Farag was happy also. On the second page of the cover letter. Then going to the third page.
Oh, let me find the page first, counsel.
Okay,
It's a flow chart.
yes, sir.
Okay, I have the flow chart.
I don't see the flow chart. Can we say again where it's at?
It's not really a flow chart, but it's a document listed 1, 2, 3, 4. It's titled flow chart, so it is a flow chart, but
Oh, okay, Your Honor.
it's basically it looks like.
On the second page,
Okay, let's go through. Okay, on the second page of the flow chart.
yeah, item number 6. The plaintiff paid $11,400, and he has an outstanding bill of $6,710 outstanding tax. I suggested to Ms. Parak earlier that I'd like to have my client pay $5,000 and take over the $6,710. Then my client's obligation will be $11,710, and then they will make a payment, and then I'll prepare a quitclaim deed, put an escrow. Once the payment is complete, then we're out of here, and we don't have any.
Your Honor, we cannot accept that. My client paid over $11,000 to the treasurer. They're only offering us $5,000. And we made an offer for settlement before. It was denied. That offer for settlement hasn't changed. Well, it might have changed because it's been a while, but Mr. Opposing Counsel did also give me the offer of his $5,000 for settlement. And again, there's no meeting in the minds for settlement.
Can I respectfully answer this question? Your client right now owes $6,710 in taxes.
What does that have to do with anything?
It has to do with the settlement because of the fact that if my client takes over the pays $5,000 and takes over that taxes, my client will be paying $11,400, $11,710. So, and they'll be they will not have the obligation to pay the taxes. In other words, they get $5,000 and get rid of the another $6,700 in taxes. I think it's a fair settlement. If she wants to go to circuit court, because I did check with the state Supreme Court Administrative Office, Your Honor, I confirmed that this court does not have concurrent jurisdiction. I could not get a letter from the administrator because he's out sick on leave, Otherwise, I would have produced that. So in the final analysis, she would have to take this court to the circuit court for quiet title. And
This is not a quiet title issue. It's the eviction issue. It's the termination of tenancy issue. The court didn't have an issue with ownership. That was presented by you.
Your Honor, I have objected to that very carefully. That is, my clients do not have any landlord-tenant relationship with them. They don't. She cannot produce a lease or any kind of landlord-tenant.
If someone is an occupant counsel, then they don't have a landlord-tenant relationship in a sense where there's privy of contract between the tenant and the landlord, but they have a connection that they're an occupant of the property, and because they're an occupant of the property, this is the exclusive jurisdiction to remove that occupant of that property. So it doesn't matter if they have a lease or not. We do terminations of tenancy all day, every day in here.
Respectfully, want to point out to the court that in the second page in summons and complaint, it says that your tenancy has been is being terminated, and there is no tenant relationship. In the summons and complaint, clearly says that it is. It's tricky with that. So if you want to go over the flow chart, Your Honor, filed 4 cases, and there is no enough time to review all those things. So I had to summarize this 67 pages of document.
And I read your motions. I read your motion. Case number 1. That is closed, correct?
Yes, Your Honor.
That includes.
Case number 1 is closed. That's not relevant.
Second case, she made mistake in the name of the plaintiff. So she keeps making me work. I don't have.
That case was not in front of me, and that case is closed.
That case is not closed, Your Honor.
Your Honor, it was closed.
No.
I filed it. It was not, but then it was dismissed.
Because you filed an amendment for the name of the.
I'm going to check it right now and tell you status. 22398-025.
Clinton, case closed,
Case
dismissal.
is closed, dismissal without prejudice is entered. Case number 3. Why is this relevant?
Number 3 is relevant because she filed this case and I have produced documents to the courthouse. She said that somehow it got filed by somebody else. It was in her own handwriting, the summons and complaint, and in her office with the case number and the hearing date and time. So she is denying that she didn't have nothing to do. That case I filed a motion to summary motion, and this court clerk called me, and I paid a $20 filing fee, and then it was supposed to be heard by her. Found out that this case was completely botched up. The property address was 9,000 East Jefferson. So she come up with all this weird cases. She denied this. I sent with my filing last time. I had my carrier take it to the courthouse, and you should see it in your package that she's the one who filed that case. Judge Brew.
23, it must be 223987771. All right, this case number 3, that doesn't even show up in the ROA. The 233987771, and we're currently on 233457771. So that case is that number wouldn't even work. So
Your Honor, she keeps filing cases, and I have to keep responding, and she keeps making mistakes and over and over. Then the cases of his
what is, Mr. Compton, what is the relevance of what is the relevance of this? Why are you telling me this?
relevance is, Your Honor, if she kept with one case and completed, there'd be no 4 files would not be opened up at the courthouse. I would be able to complete the case properly. She did not even file a motion with the initial court filing with Judge Alicia Jones.
Are we talking about the case ending in 233457171 LT? If we're not out, all these other cases are closed.
Your
I
Honor,
don't these cases.
that she used the same date, 11/22/2022, the same like a motion.
Okay. Counsel Parat, did you,
Yeah.
in the case ending in 233457171, was the notice to terminate, what was the notice a new notice? Or did you use an old notice for that matter?
The notice I used for 171 was the same notice I used for the case with Judge, oh, please forgive me, Your Honor. The case with Judge McClinton, which is 025. I did have a mistake on the summons. I immediately filed the motion. At that hearing, both of us were present. She explained, Ms. Parak, if you dismiss this case, you can refile it tomorrow. It will be heard faster, and then you can fix your mistake. So yes, I used the same notice. Everyone was there. Everyone heard. We still required to have the property back. I did use the same notice. And as I've pointed out in my brief, a notice has to be given. That is true. And the notice was given, and we cannot file a case until after the notice. So when the notice expired, we filed, we had a mistake. Then we were asked to refile the case immediately, and we did, Your Honor.
So the case was dismissed. It's the same issue, same defendant, same parties, same address.
Yes, Your Honor.
Yes, as
So
the
that-
one with Judge
So
McClinton.
So, Mr. Conker, how, when all parties were there present at the previous dismissal, how is it that your defendant is harmed by lack of notice?
Your Honor, my defendant is harmed because of the fact that the defendant's attorney had to be present in every one of the repeated cases. She could have.
Hold on, whoa. How, you said he's harmed because you had to be present at the cases?
Your Honor, because of the fact that my time is not free. She keeps filing more cases for the same, against the same party, same with identical issues. And how does she, think that my time is?
We're talking about McClinton, the case that was filed, it was dismissed, and then she refiled. So you got a dismissal. That's water under the bridge.
She filed the Judge Brew cases. That was the next case she filed.
Okay, and the case number doesn't even plug into the computer, so I really don't know which case that was.
Yes.
Judge, I'm going to formally state I did not file that case. I do not know what he's talking about. I just want that on the record.
Can you type in Brea Patterson? Thank you. BREA.
BREA.
Yeah, and then Patterson. Yeah. Brea Patterson and that.
Let me try it another way, Judge.
Okay, so what was the harm, Counsel?
Your Honor, I would respectfully request, Your Honor, if I have to attend in the court, I have to bring up the old record, and because you would have to take time to follow everything, because if I want a reference, then you have to go through the 4 cases, all files, and that's why I have to spend time in summarizing for you so that you could easily understand what's going on, because without some kind of reference, you would be able to decide anything. So, on top of that, may I complete the other? She also asked Your Honor so that she could file a response to my 523 document. She filed about that.
I can't even hear you, Mr. Conker, and you know we've had this problem from the beginning.
She misquoted the, she took out the chain citation and put a in between,
I didn't hear what you said.
she made a serious mistake, and I did file the response to that.
If I may address that, Your Honor. Your Honor, I'm dyslexic. Okay. I don't want that to be out personal known, but it is. And I try very hard when I do my stuff. Did I make a slight typo? I did, Your Honor.
It's not typing.
It's under number 3 of what I typed in. It does not change what the actual law is. Instead of putting a period, I put the word but and added 2 sentences together.
No, you.
I put the word but and added 2 sentences together. The case citation is correct. Inside it was cited to another case. So I do have double case citation, which is not there. That is a typo, but it does not change the law that is there. It is a typo. I will admit it freely, Your Honor. And it says, mere peaceful possession alone is not sufficient to acquire title by adverse possession. It should be a period. I put the word but. There must also be an element of hostility. That is the correct law. Opposing counsel has also cited that.
Why are we even talking about adverse possession?
Your Honor, that's a great question, because adverse possession happens to actually be someone who has color of title, and you have to go to the circuit court. And if you have color of title, you are allowed to go to the circuit court and sue for the actual title of it. Mr. Conker is using that as a way to say that his client has control of this property and has a good title. My client bought it at a tax sale. His client did not pay the taxes. He says his client has been in peaceful possession for 50 years. That may be true, Your Honor, because they've owned it before, but that is not hostile. As I have pointed out, it is something that is irrelevant to this case. It's a tax sale case.
Please respond.
That is it.
Let me respond. In this case, what is the plaintiff that I will pay this off, taking federal loan? How is it hostile?
It's not adverse possession. Who's this property? Who did the property? Who lost the property taxes?
I do not understand the question, Your Honor.
Was the property lost at the tax sale? Was your client foreclosed, Mr. Conker?
No, my client did not lose possession.
Was your client? Did Wayne County Treasurer's Office foreclose the property that your client Did they foreclose the property? What is this?
The plaintiff did not get a deed from the warranty deed from the county.
Okay, judgment
Which
for plaintiff. Judgment for plaintiff. I have a quit claim deed. It came from the Wayne County Treasurer's Office to Ms. Parak's client. This case, it was filed once. This is filed twice. You filed a motion saying that the court doesn't have jurisdiction over landlord-tenant cases.
Yes.
Which is, you also filed saying that adverse possession applies. It doesn't apply. You keep making these arguments. You keep trying to negotiate. I don't understand what the basis of your argument is. I still don't understand what the basis of your argument is. Parties admitted to being in front of Judge McClinton. She dismissed the case and said you can refile it immediately, which is what she did. You can't demonstrate any harm that was caused to your client who was attending the last hearing and knew that a lawsuit was coming immediately. And now you're fighting the notice issue when you really probably need to be in Third Circuit arguing or fighting for the property there. But it's not here where you're gonna win an adverse possession claim or convince me that I don't have jurisdiction at 36th District to conduct an eviction. I mean, I'm not gonna conduct the eviction, but enter a termination of tenancy judgment. So I'm going to give you, before I make this judgment, please, what issues are still relevant that would lead this court not to enter a judgment in favor of the plaintiff?
Respond, Your Honor.
Yes, absolutely.
Respectfully put in the record that my client never lost possession of the property, regardless of any kind of judgment. I
can't accept that argument because I have a quit claim deed from the Wayne County Treasurer's Office. If I don't give any weight to this deed, then that means every other deed that comes in front of me, I have to just say, oh, well, maybe they don't get possession. Oh, maybe, well, the governmental function is ineffective and we do whatever we want to do. Because what's the alternative to not honoring a deed? It's not a warranty deed, but you don't have a deed that's presented greater than that. And your argument is with the Wayne County Treasurer's Office. It's not with 36th District, and whether the foreclosure was proper, they already have a deed.
Your Honor, I have already submitted a well-researched brief, and it is in your possession, Your Honor. Adverse possession is a question of intent. It's a question of fact. It's not just because somebody got a judgment. That is not accurate. That's why I said that election of remedies. You can order this case to be transferred to the circuit court, then I'll take it from there. That's why
But you need to, because the person has a deed, and because they have a deed, they have a right to regain possession of their property. So let's go through your motion, all right?
my motion is
Summary dismission in lieu of an answer. I'm gonna go through your motion. You said that Parak knowingly made misrepresentations. I'm gonna ignore that. I'm gonna deny that part of the motion. You're bringing up, she made misrepresentations because this property was occupied by the Earlys for 50 years. Ardell Early paid $10,000 and conveyed it in 1992. That's not relevant.
Your Honor, may I?
Hold on, I'm not done. No, not yet. Issue number 2, whether plaintiff made representation as to pendency of a landlord-tenant case in 36th District, which has no equitable jurisdiction. Defendants are not renters in 36th District is not a proper form. That's incorrect. Res judicata will not apply, does not apply in landlord-tenant evictions. You know why? Because the date changes. The date changes. So it's not the same issue because they're still in the house. You're not gonna, just because one eviction wasn't dismissed, it wasn't dismissed with prejudice. Was it?
No, because it could have been, because that's what the Judge Coleman, Alicia Coleman said she's going to do. But that case was transferred to Judge Sean Jacks, and he did not quite understand the whole situation. That's why he signed instead of with prejudice. He signed without prejudice. I already immediately filed a response to Judge.
How can a real estate eviction be dismissed with prejudice?
Because of the fact that the plaintiff's attorney did not attend the case.
Let's take it up.
Waited for 6 or 7 hours ago. She did not call, and she had no good excuse. She did not file a motion or any kind of affidavit with a good cause. She did not do that. So the judge asked her to do that. She did not do that. I realize a person may have problems. She may have problem on that date. She could not come to the court, but she could easily call the court. She didn't do that. She did not file a response.
What are we talking about, Ms. Barak? What is it?
Connor, with all due respect, I missed a pre-trial. I had an emergency that day. And I had an emergency inside my office. I did call the clerk the next day and she told me, Ms. Parak, it was dismissed without prejudice because you missed it. And therefore, I issued a new notice that time to get another case started because the notice that I had was old and was defective, not necessarily defective, but it was old and it was time for a new notice. You're right. I did not go back. She did not order me to go back and reopen the case. She said, Ms. Parak, it was dismissed without prejudice. That's what was in the ROI. Now, opposing counsel filed a judgment, a default judgment, and she refused to sign it. Months went on when finally I was starting to be contacted by the court asking for a dismissal. I had explained the reason why the case was dismissed, that it was my fault. I have never said that it wasn't my fault. And I did finally submit a dismissal. However, the court redid it, which they had to because it was coming from me and it wasn't, I was the one at fault. So the court did not, and never in the register of actions did it dismiss with prejudice.
It was not because
again, it was a pretrial, Your Honor, and the first pretrial, generally it is always dismissed without prejudice. You then have a choice whether or not you want to go back and open up the case. In our landlord-tenant case, if you decide to move forward with a new notice, it's a new case.
If you dismiss something with prejudice and landlord-tenant, it ruins the marketability of a house. Just think about it. It doesn't, I mean, it may be possible, but I haven't seen a situation where that makes sense unless the
I made
transaction occurred.
Your Honor, she said she spoke to the clerk, she didn't talk to the judge, but I did.
I'm not going into that. I don't care about that. Okay. Issue 2, whether plaintiff violated the legislative purpose of GPTA. I'm going to deny this because it lacks relevance to this landlord-tenant matter that we're in front of. You're saying the conclusion, Mr. Aflume has no intention to revitalize the property. You don't know that.
Yes, Your Honor.
But how do you know what you're presenting to me?
Your Honor, Mr. Ofume wants money. There's no way.
I don't care what he.
How can he?
Aflume paid $11,500 more or less, and he's asking for $20,000 from defendant. Thus, he is trying to make a quick profit. That doesn't matter to me. That's not my business. That's not my business. I don't go policing people's deals. That's none of your business either. Unless, I mean, I guess it is because you're in negotiations, but that doesn't have anything to do with me. And negotiations aren't supposed to be presented anyway. All right. Issue number 3. Issue number 2 is denied. Issue number 3, whether plaintiff's attempt to sell the land and collect excess money has converted him into a debt collector with the assistance of counsel Kathleen Parak, who did not provide a debt validation notice. So are you saying that Ms. Parak needs a debt validation notice and she's considered a debt collector because she's filing a termination of tenancy complaint? Is that your position?
She's trying to collect money way more than her client paid. Also, there's a case in the Oakland County Circuit Court. It was Raffaelli versus Oakland County Treasurer.
No. We're jumping to the
That case is relevant. That case is relevant here. I quoted that case in this.
Okay, all right, go ahead. It hasn't Wayne County hasn't given back a cent yet, but go ahead.
And it is in the brief. Any access property belongs to the rightful owner. So therefore, it will be under 14th Amendment. If that money that they're going to collect does not belong to Mr. Ofuma. It will belong to the person who is now.
Go get it from Wayne County. Go get it from Wayne County. She doesn't owe you that money. They didn't sell the property on auction.
Your Honor,
how is that even an issue? How is that an issue
GPTA
relevant to me? How is that an issue relevant to 36th District Court? You're saying that someone's profit from an auction, a governmental municipality's profit from the auction based on case law, you're saying that they can't profit. And it's the Supreme Court ruling that said municipalities can't profit. You're 100% correct on that. And I don't know what's going to happen. I don't know how much money is going to be given back, but Ms. Parak's not going to give it back. Ms. Parak's client's not going to give it back. And 36th District is not going to give it back to you. So why are we even talking about this right now?
It was auction for auction. It was $4,900. $4,905 was the amount owed. And he meaning that plaintiff was the successful bidder for $11,400, I believe. Therefore, the money that is the excess money doesn't belong to him. Your Honor, also GPTA, you summarily rejected my argument. GPTA is intended for neighborhood development and also because that is the purpose, And she's quoting GPTA all the time, but yet the legislative purpose of GPTA is neighborhood development and bringing the money to the treasury and for purpose of redevelopment. It is not just to make a quick profit.
What? No. I'm not even accepting that argument. That's not even relevant to this court. This is a landlord-tenant auction. This is an eviction for termination. This is a request for a termination of tenancy post-auction purchase. They have every right. They have every right to their property.
Your Honor, this is not a landlord-tenant case. It is a misnomer because I have heard there are other attorneys have argued before the same situation. In other words, the people who are buying properties from the land bank and GPTA, they're using this court as a short circuit to get a title to the property because they should be going to the.
I'm not granting any title, but I am granting possession. I am going to grant possession. I'm going to grant possession.
Your Honor, as a practical matter, they could not get a possession of the property because their remedy at law is adequate. Law is adequate. They cannot show irreparable harm, because the fact that the money damage is the only thing that you can award, Your Honor. Because
all right, Mr. Conker.
Money damage is because the fact this building is inside the property. In 1967 during riots, there's part of the building got burned down. My client's father, he boarded up the outside and then it became a part of it was a small portion.
Ms. Parak, because I asked you to stop talking earlier, counsel, you just ignored me, so I just muted you. I'm gonna miss the mute button next week. Ms. Farad, how much time are you willing to give Mr. Early?
My client, due to the fact that this has been ongoing for many, over a year, my client is asking for 10 days.
Now, when was this case filed?
This case was filed originally in the January, then it was refiled in March.
2021.
Okay, all right, well, all right, so how much time does your client need, Mr. Conker?
Your Honor, my client cannot move out of the property. This is the only repair shop in the area. And Your Honor, this property that is 1727 is not, it cannot be recognized from the outside. You know, it have to go inside my business, inside my client's business. There's no way they can occupy the property, because if you send somebody over from the court or the police station or whatever you want to do and take a look at it, because
It's not an issue of occupancy or whether the property is habitable or not. It's just being there. Maybe they want to put a picnic chair in the middle of this rubble. They have every right to do it as a property owner.
Your Honor, let me ask you a big favor. I want some alternate dispute resolution in this matter. Okay, instead of getting a judgment right now.
You are not entitled to that. There's a judgment by hearing. This is a termination of tenancy matter. Mr. Early must vacate by June 12, 2023.
How is it going to vacate, Your Honor? Because
I give them until June 20th. I'll give them until June 20th, 2023, or a writ of eviction may issue.
well, Your Honor, I'm not quite able to make sense to you, because the fact that this property, this small portion, it is within the business BTS auto repair shop. It is in the repair shop. If they want to have somebody go inside the property and sit down there with a chair, and that's the only way they can occupy. The money damage is the only remedy that is to be offered, because money damage is adequate.
The case is, Mr. Conker, you can appeal this matter, and I know you will. You can appeal it and challenge it, but this case is resolved in this courtroom.
What is the date?
5171, there's a judgment by hearing for June 20th, 2023.
I'll submit that today, Your Honor. Thank you.
You're welcome. And for the record, I denied your motion.
For the record, I requested an alternate dispute resolution. For the record, this is improper, because this court does not have equitable jurisdiction, and only money damage is adequate. Therefore, possession is not a proper remedy.
Okay, so you're saying that money damage is the only remedy that I can grant in 36 District Court landlord tenant?
I'm not telling you you're limited to that. I'm saying that.
You just said the exact same word, that is the only remedy. Money damages is the only remedy, and we have no equitable powers. And I'm not gonna, whether or not we have equitable powers, but I can tell you that I have power to issue a termination of tenancy judgment, and that's not a monetary judgment. So I must be able to do something outside of issuing money damage. So judgment by hearing June 20th, 2023. That's the parties must vacate by that date.
How is going to vacate, Your Honor?
I don't know. All occupants. Is there any, actually, I'm just gonna leave it as it is. It's not my case. So So
It's not a practical matter, Your Honor. As a practical, it cannot be done.
your motion wasn't practical, and we're moving on, counsel.
Okay, Your Honor, if you say so, but I do think that.
You didn't even put your camera up today. You didn't even put your video up to even argue the motion. And you don't have to now, and that's not, I mean, it's just like, I gave you time to speak, I gave you time, I didn't cut you off, I mean, I cut you off a few times when it was irrelevant, but you've had every opportunity to make this argument, and you spent time making an argument, and I didn't even highlight the fact that you're just accusing and opposing counsel of all types of wrongdoing and asking for sanctions and whatnot, but hey, your parts in law, you're arguing on behalf of your client, that's not the issue. The issue is that you didn't have an argument that would defeat a landlord-tenant termination of tenancy judgment with the deed in the file. So that's the final judgment. If you appeal it, there's fine, that's within your right. But today, I'm awarding possession to the claimant who was presented a deed. Go ahead.
The record, this is a proper case for possession, Your Honor. And
What did you say?
thank
A
you.
proper- I didn't hear what you said.
It's a proper case for adverse possession. Not for, not for,
Okay.
not for, not somebody else, because it's a practical. So thank you for your time, Your Honor.
Thank you for the effort. You all both dedicated a lot of time to this, so that's appreciated by the court, but I'm
Yeah.
still rooting.
Your Honor, I've been a very respectable member of the bar, and in your courthouse, all the people that I used to know there are retired or died, you know. Judge Marianne Moore was my classmate, you know, she passed away. So they never, you know, questioned my ability to make.
Well, I'm questioning it. I'm questioning it, and it may not be your ability, but I'm questioning your rationale for this case. You may be a whiz at something else, but when it comes to landlord-tenant termination of tenancy and this specific issue, I disagree with you. So that's fair. I can disagree. I disagree with people all the time. And it's no disrespect, counsel. It's just
Okay.
it didn't work.
Okay.
Tell me who believes in you and
Thank
who
you.
doesn't. Thank you.